Assalamualaikum warahmatullahi wabarakatuh. This is part 5 for the lecture on the topic consideration. It is recorded via Zoom. So in the earlier part, part 4, we covered about forbearance susu and as well as performance of existing duty and public duty. So in part 5, we are going to look at the subtopic of accord and satisfaction. So actually another equivalent topic or another way, or we can also use this as it relates to part payment of a debt. That's the meaning of the word accord and satisfaction. Okay, we go to English law and then we are going to compare with, we are going to look at the position in Malaysia. So under English law, if one person owes a sum of money to another, to the debtor, in the position of the debtor, and he agrees to pay part of this in full settlement. If the amount of the debt is 100K, but he agrees to pay, I agree to pay you 50K in full settlement of 100K. All right. So is it a good consideration? Okay. So the rule at common law or the rule in penal's case, which was reported near 1602, 17th century. So the rule is that part payment of a debt is not good consideration, okay, for a promise to forego the balance. So let's say later the creditor wanted to claim for the remaining. Yes, he could do so. Legally he can enforce the remaining. He can ask for the payment of the remaining debt here. That's the rule at common law. Okay, so that's the example that I have stated just now. If A owes B 50 pounds and B accepts 25 pounds in full satisfaction of 50 pounds on the due date, and then later, there is nothing to prevent B, the creditor, from claiming the balance at a later date. Because why? There is no consideration, proceeding from A to enforce the promise of B to accept part payment. Because why? He is already the debtor. He is already bound to pay the full amount. And actually, it tallies with the principle, the rule as enunciated in the case of Sikh and Marek. And another reason is that it protects a creditor from economic duress of his debtor. Maybe the debtor say, "Oh, you either accept or I won't pay you at all. So please accept. You have to accept in and take take it as a full settlement of the debt." So the law wants to avoid that from happening. Let's have a look at what happened in penal's case. Because the rule is, the rule originates from this case, penal's case, 1602. What happened was that owed penal 850 basically, 8.50 shillings here, which was due on 11 November. And at penal's request, Cole paid part of it, £5.11 on 1st October earlier. And penal agreed, accepted in full settlement of the debt. The full debt is 850. And then later, penal stood call for the amount owed. Here later he asked for the remaining basically. So the court held that part payment in itself was not consideration, but there's exception to it. But it was held that agreement to accept part payment would be binding. It is good, valid, if the debtor at the creditor's request provided some fresh consideration to justify the part payment for the full settlement. This is an example of fresh consideration. So consideration might be provided if the creditor agrees to accept first part payment on an earlier date, like what happened in penal's case, or maybe payment in form of chattel, instead of money. For example, payment by way of giving a horse, hog, or rope, or maybe which has more value compared to money. For example, on this maybe jewelries, gold jewelries have more value. So instead of paying with the money cash, so payment in gold bar, for example. Or another fresh consideration is part payment in a different place to that originally specified, and usually it is to the advantage of the creditor, maybe at the place of creditor, or maybe nearer to the place of creditor. It gives some advantage, okay, to the creditor. So it is all, I mean, they are all considered as fresh consideration, then it is good and valid. Okay, I mean, it constitutes fresh consideration plus the partial settlement of the loan. Is in, I mean, and it is being considered as full settlement. Okay, so is it a good law? Okay, despite its harshness, the rule in Pinel's case was affirmed, okay, by the House of Lords, and it actually still represents the law today. Okay, it was, I mean, it was upheld, okay, in the case of Fuchs and Beer, 1884. Here, Beer and Mrs. Beer. So Mrs. Beer had obtained judgment for a debt against Dr. Fuchs. So Fuchs is a doctor who subsequently asked for time to pay. And Mrs. Beer agreed that she would take no further action. Okay, I won't be suing you, okay, in the matter, provided, okay, Fuchs paid £500 immediately, okay, and the rest, okay, by half yearly installment. Meaning you paid me 500 first, and then you can pay by installment later, okay. And Fuchs duly kept, meaning that here Dr. Fuchs here, he agreed, okay, duly kept to his side of the agreement. But judgment that because it is not paid at once, okay, it carries interest. I mean, the amount is increased because it comes with the interest. House of Lords held that Mrs. Beer was entitled to the 360 interest which had accrued because it takes some time, okay, to really make the full settlement, okay, of the loan here. So it carries 360 pound interest here. And then the court held that Fuchs had not bought her promise to take no further action on the judgment. Okay? He had not provided any consideration. So basically, the court actually upheld decision in Pinel's case actually. Okay? Unless you can prove there was fresh consideration. Here, there's nothing. I mean, there's no fresh consideration. So she was entitled to the interest. Now we want to know what's the position in Malaysia. So is it recognized? Is it valid? Yes, under Contracts Act 1950, payment of a lesser sum, okay, which is the rule of accord and satisfaction. Yes, it is good consideration in Malaysia. How do we know? Okay, we have section 64 and illustration B. Okay, so the rule is that a debt is discharged by accord and satisfaction. And then accord actually specifically refers to the agreement that discharged the obligation. And satisfaction is the consideration, okay, that makes the agreement operative, valid, and legal. So I reproduce exactly the wording of section 64. Every promisee may dispense with or remit wholly or in part the performance of the promise made to him. Or, I mean, legally speaking, okay, the promisee may extend, okay, the time for such performance or may accept instead of it any satisfaction which he thinks fit. So legally he has the option, the rights, okay, to do it, okay, to dispense with or to just accept partial payment in settlement of the full payment. We also have illustration B, so we still need to go to Contracts Act to have a look at section illustration B of section 64. Illustration B, 64. Scroll down. So where is 64? Okay, illustration B here. A owes B 5,000 ringgit Malaysia, and A pays to B, and B accepts, okay, in satisfaction of the whole debt, 2,000, paid at the time and place at which the 5,000 were payable. So the whole debt is discharged, okay, provided B agrees, okay, free consent, agrees to it. So I mean, there's no fresh consideration right here. So basically, in Malaysia, it is recognized, okay, provided it is accepted. I mean, the party has the right, okay, to accept. We go back to the slide. Okay, we have a case here. Associated Pan Malaysia Cement Sdn Bhd and Syarikat Technical and Kejuruteraan Sdn Bhd reported year 1990. So the case is important because why? It shows, illustrate the application of section 64, which does not require agreement and consideration. It's possible for the parties to agree among themselves here. So section 64, if you were to compare with English law, it is different. So that's why it is clearly stated in the judgment here. Section 64 of the contract, Section 1950, it represents a departure. So, I mean, we depart, okay, we are different, okay, from the common law in England. So, Section 64 actually is similar to Indian law, okay, on the general principle of waiver. I mean, here, the promisee, the party to the contract, has a right to waive certain obligation which is imposed earlier. So, it is open to a promisee to dispense with or remit wholly or in part of the performance, okay. And under Malaysian law, okay, neither consideration nor an agreement is necessary. No need to provide, approve fresh consideration. No need to sign into a fresh agreement. Okay, it's possible. Okay, so accord and satisfaction in Malaysia is valid. Okay, it is good. It is recognized. Okay, and even what more? Okay, payment of a lesser sum here, even though it is furnished by a third party, yes, provided it is accepted by the creditor, it will discharge the whole debt of a debtor. It's not the debtor who paid, but maybe some other person assists in payment. Yes, that one also will discharge the whole debt. We have read illustration C just now, okay, and we have the case of Kirpa Singh and Bariam Singh reported in year 1966. This is a appeal case. So the trial court can allow the application of the respondent debtor. So the respondent was a debtor to set aside a bankruptcy notice taken out by the appellant creditor. So creditor was the appellant against him and one other person basically was the basis on the ground that the judgment debt has been satisfied by the tender by a third party of a check for a smaller amount than the sum due as payment in full. Meaning here the debt was actually paid, okay, by a third party, somebody else, okay, on behalf of the debtor. But it's all a smaller sum. It was paid by way of check, okay, and the check was accepted, okay, and cashed by the creditor. So the act of cashing out the check by the creditor means that here you agreed to accept smaller amount, okay, in satisfaction of the, and it's considered as full payment of the debt here. And the court make it clear, okay. Section 64, okay, it materially alters, okay, the English doctrine of accord and satisfaction, okay. And on the facts of the case, okay, it is very clear that a third party made an offer subject to conditions, and under those conditions, the creditor, okay, could either return the money to the offeror, or the creditor could retain the check, okay, and if the creditor retain and cashing out the check, then it will discharge the debtor's liability. So if you decided to accept the check, it means you agreed, okay, to let go the remaining of the debt basically. So the creditor's conduct in cashing the check and retaining the money, so it amount to agreement actually. Okay, we can infer that this is an agreement to discharge the debtor from any further liability. No need to pay the balance of the loan basically, right? So again, the issue, we have another case here with the issue is that whether the act of the promisee dispense with the performance of the promise made to him by the promisor. So the case is Pan Ahbar, okay, Pan Ahbar and another, and Nanyang Construction Sdn Bhd and Nanyang Construction Sdn Bhd, 1969. Let's have a look what happened in this case. So this is an appeal case. Plaintiff, so later plaintiff were the appellant, okay. Plaintiff were administrators of the estate of the deceased, and the deceased name was Ng Lai Hung. F is female, okay, female's name. So the administrator, they claim for the return of $10,000, okay, deposited by the deceased with the respondent company, okay, who was the respondent housing estate company. Because why? The deceased, during her lifetime, okay, when she was alive, she executed, okay, she signed a printed document under which she confirmed her intention to purchase from the defendant company a 3-story shop house. Okay, the price is 88,750. So when she was alive, okay, she signed certain document. She intended to buy, okay, this property. And then she paid the deposit actually, okay. She paid the defendant company 10,000, okay, and the execution of the document. But later, okay, maybe she had a change of mind. So she failed to sign a formal agreement. Okay, and actually the company solicitors, they prepared the document and they made a repeated request, please come sign document whatsoever. And in one of the letters, okay, they have exchange of letters here, dated 20th August 1964, okay, the company actually wrote in the letter, okay, inform her that if you fail to sign the document, okay, within 7 days, okay, the company will sell the property to other purchasers on its list. So that's what was being written in the letter. If you didn't want to proceed, if you didn't sign the document, so we are going to take action, basically. We are going to sell off the property to other buyers, all right? And then later, the deceased wrote to the defendant company. And then he said, yeah, please sell it to other buyer. Requested it to sell the property to other purchasers. And please return my deposit. I didn't want to proceed with the purchase. So that's what happened, okay, between the deceased and the company. But then maybe the company didn't manage to sell it to other purchaser. Okay, it's just a trap. I think that's my guess lah. That's why, because what happened was that after 3 months from the letter's date, defendant company again wrote again to the deceased, repeating its previous request, and then at the same time pointed out that this was the last chance to be given to her, and unless she signed the agreement and paid the certain amount here, transaction was to be cancelled. We are going to cancel, okay, the transaction, and then the deposit will be forfeited. They are going to forfeit, okay. They are not going to return the deposit, and they are going to sell the property to other purchasers, okay. And then plaintiff, okay, now sued the defendant company for the return of the deposit. Okay, what's the ground? On the ground that the company had rescinded the agreement when they informed the deceased that they will sell the property to other purchaser, okay, if she failed to comply with the request. So now what's the main issue? Okay, now the main issue is that whether the defendant company, okay, the housing company, okay, by its letter dated 20th August, they had dispensed with the performance, okay, of the promise made to it by the deceased. When they said, okay, if you don't sell, we are going to sell the property to other buyers. Does it amount to dispense with the performance? Okay, let go the performance on the part of the buyer here. The court held that Section 64, okay, of the contracts ordinance, before it becomes act here, it provides that every promisee may dispense with or remit wholly or in part of the performance of the promise made to him. So what's the implication here from the letter? When the deceased had failed to sign the agreements as requested by the letter of 20th August, actually the company had dispensed her from performing her part of the contract. With the result that what happened? Okay, the contract was rescinded, okay, was set aside. So the estate of the deceased is entitled to the return of the deposit. They cannot simply forfeit the deposit. Later, okay, they wrote another letter saying that they are going to forfeit the deposit. But the court, the effects of the letter dated 20th August, actually it amounts to dispense the performance of on the part of the deceased or the purchaser. Okay, so that's it for this part. Okay, we're going to continue in part 6 later.